When does it make sense to file a modification? Hi, I'm Bill Farias, founder of Farias Family Law. We just got this question last week specifically about a custody issue, and this comes up all the time where people finalize their divorce or custody proceedings and then something changes and they need a change in the court order. So this video is to help you figure out when it makes sense to actually go ahead with a modification case and file it. So the first scenario is child support, and I'm going to treat that separately because the standard is different. When it comes to child support, if the numbers that you calculate using the child support guidelines and calculator result in a presumptive order that is different than the one in the current court order, then you potentially have grounds for a modification. So the caveat to this is that if there was a deviation from the guidelines in the last court order, and the reason for that deviation is still present today, then that's something that you have to factor in because it's something that the court would likely consider. So child support, if the number that you get from the calculation right now is different than the one in the order, then you likely have grounds for a modification, except that you have to factor in a deviation if there was one previously, and those circumstances still apply. Now, the next category of modifications includes everything else, and this is usually child custody or alimony. It can also be health insurance, life insurance, but usually this comes up in child custody or alimony. And the standard for a modification is a material change in circumstances. So what exactly does that mean? It means that it has to be a change that has a significant or can have a significant impact on the parties. So if it's a minor change, then it's not worth filing. It might get kicked out. If it is a material change or you think it falls into that category, then what I would suggest is talking to an attorney about whether that's going to meet the standard and also doing a cost-benefit analysis, right? Because sometimes you might think something is substantial, but when you consider the time, the energy, and the cost that it's going to require to change that order, then you might decide it's not worth it. So modifications for custody, these often come up when there has been, for example, a significant shift in the parenting time. So let's say the order called for 50-50, but now one parent has the child the majority of the time. Somebody might want to modify under those circumstances, sometimes because they want the designation for full custody, but also some more support. Another scenario where this often comes up is that there's a parent that goes off the rails, unfortunately, right? Whether mental illness, substance abuse. So you have a parent who has significant parenting time, but then something happens and it's no longer in the child's best interest to spend as much time with that parent. That is a circumstance under which it usually makes sense to file. The other scenario that is very common is alimony. So if somebody is paying alimony and the person paying has realized a significant decrease in income, and that person is making every effort to remain employed and to earn as much as he or she possibly can, but the numbers are just down, then that's another scenario in which it makes sense to talk to an attorney about modifying. So same circumstance, same idea as in the child custody scenario. You got to make sure that it's going to be worth it. So you have to run a calculation to figure out, in talking to an attorney, what your potential gain is from filing if everything goes smoothly and you get what you ask for from the court, versus how much you're going to spend to get there. And it's usually in the scenario of alimony or child support, strictly a numbers game, so you can figure out what your potential gain is and what you're going to have to spend to get there and determine whether it makes sense to file. So overall, whether it makes sense to file a modification, first of all, I would caution you to talk to an attorney before you actually file anything, because when you file a modification, you're subjecting yourself to counterclaims. So when you're inviting someone to court on a modification, if they have anything they want from you, they can counterclaim. And then that puts you in a situation where you have to defend that counterclaim. So it's not as simple as let's just give it a shot. You want to make sure that you have solid grounds and that you don't have high exposure on any counterclaim issue. So I highly recommend you talk to an attorney before you file a modification. But overall, when it comes to child support, you got to look at what the calculation would result in now versus the previous order. And for all other issues, the standard is material change in circumstances, and that can be very difficult to define. So talk to an attorney to see whether you meet the standard and do a cost benefit to figure out whether it makes sense to file. If you have any other questions about this, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel, share it with anyone you think might benefit from it, and you can find us on social at Farias Family Law. Thank you. Have a good day.